Delaware is a small state with a surprisingly well-organized approach to landlord-tenant law. If you own rental property in the first state, your primary reference is the Delaware Residential Landlord-Tenant Code, found in Title 25, Chapter 51 of the Delaware Code. This statute is comprehensive and provides clear guidance on what's expected of landlords. Under Section 5305, Delaware landlords have a detailed set of obligations. You must comply with all applicable building and housing codes that materially affect health and safety. You're required to make all repairs and do whatever is necessary to keep the premises in a fit and habitable condition. Specifically, that means maintaining the structural components in good repair, keeping plumbing systems working with hot and cold running water, ensuring electrical systems are safe and up to code, providing adequate heating capable of maintaining a reasonable temperature, maintaining any air conditioning or ventilation systems supplied with the unit, providing working smoke detectors on every level of the dwelling, keeping common areas safe, clean, and properly lit, providing adequate trash receptacles, and maintaining all appliances supplied by the landlord in working condition. What makes Delaware interesting is the state's size and how that affects enforcement. With only 3 counties, Newcastle, Kent, and Sussex, and a relatively small number of municipalities, the regulatory landscape is more manageable than in larger states. But that smaller scale doesn't mean lighter regulation. In fact, Delaware's code is quite detailed, and the state courts have a well-developed body of case law interpreting landlord obligations. Newcastle County, which includes Wilmington and the most densely populated part of the state, has its own local housing code that adds additional requirements beyond the state statute. The city of Wilmington has a rental licensing program that requires properties to pass inspection before they can be leased. Landlords in the Wilmington area should be aware that they're operating under both state law and local ordinances that may impose stricter standards. Delaware's repair process follows a structured notice framework. When a habitability issue arises, the tenant must provide the landlord with written notice of the problem. The landlord then has a specific timeframe to respond. For non-emergency conditions, the general expectation is that repairs be made within a reasonable time. Courts typically look at the nature of the problem and the complexity of the fix. For conditions involving essential services, heat, water, electricity, the response time must be much faster. If the landlord fails to act, Delaware gives tenants a solid range of remedies. Under Section 5307, if the landlord's non-compliance materially affects health and safety, the tenant can deliver written notice specifying the problem. If the landlord doesn't remedy the situation within the required timeframe, the tenant can terminate the rental agreement. The tenant can also recover actual damages caused by the non-compliance. Delaware also has a rent escrow remedy, which is a significant tool for tenants. Under Section 5308, if a landlord fails to maintain the premises after proper notice, the tenant can petition the court to pay rent into an escrow account. The court holds the funds and can release them to the landlord once repairs are completed, or apply the funds toward making the repairs if the landlord continues to be non-compliant. This process requires the tenant to be current on rent and to have given proper notice, so there are safeguards against abuse. One area where Delaware has been particularly progressive is the requirement for summary of rights. Under Delaware law, landlords must provide tenants with a summary of the Landlord-Tenant Code at the beginning of the tenancy. This summary must be in a form approved by the Consumer Protection Unit of the Delaware Department of Justice. Failing to provide this summary can affect the landlord's ability to enforce certain lease provisions. Delaware's climate is moderate compared to states further north, but winters can still bring freezing temperatures, ice storms, and occasional heavy snow, especially in the northern part of the state. Heating systems need to be in reliable working order, and landlords should also be mindful of moisture management, since Delaware's proximity to the coast and the Chesapeake Bay creates humidity that can lead to mold issues if ventilation is inadequate. The state also requires landlords to address lead-based paint hazards. Properties built before 1978 are subject to federal lead paint disclosure requirements, and Delaware has additional provisions under its own lead poisoning prevention regulations. Landlords of older properties should be familiar with both the federal and state requirements. Delaware's anti-retaliation protections are found in Section 5516. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant exercising any right under the Landlord-Tenant Code, including making a habitability complaint, contacting code enforcement, or participating in a tenants organization. The statute creates a presumption of retaliation if adverse action is taken within 90 days of the tenant's protected activity. For the full guide to Delaware habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord-Tenant Law series.